Good morning, everybody. I am Guillaume van der Loo. I'm a research fellow at the Egmont Institute, and it is my pleasure to welcome you to our webinar on extraterritorial sanctions and the revision of the blocking statute. So we will mainly discuss the blocking statute this morning. As you may know, the EU introduced the blocking statute in '96, mainly as a response to the US extraterritorial legislation or sanctions legislation on sanctions concerning Cuba, Iran, and Libya. And the blocking statute mainly aims to protect EU operators from such extraterritorial sanctions by prohibiting compliance with them, nullifying the effect in the EU of any foreign court rulings based on them, and allowing EU operators to recover in court damages caused by them. Now, the blocking statute, or its annex, as you may know, was recently updated in 2018 to deal with the reimposition of the US extraterritorial sanctions towards Iran in the context of the withdrawal of the US from the JCPOA, so the Iran nuclear deal by the Trump administration. And actually, figures from the European Council on Foreign Relations have shown that the reimposition of these sanctions against Iran have cost the EU more than 80 billion euro in direct losses. So just to illustrate that, these extraterritorial sanctions are something that matter. The regulation is now 25 years in place, and the Commission thinks that the time has come to amend or update the regulation. In a communication from earlier this year on the European Economic and Financial System, the Commission announced that it considered amending the blocking statute to further deter and counteract the unlawful extraterritorial application of sanctions to EU operators and to streamline the application of the current EU rules. There are several reasons for that. There is a proliferation of extraterritorial sanctions legislation. EU operators are increasingly exposed to them, but I'm sure that we'll come back on that later on. In the meantime, the Commission is cooking up another instrument that is a bit linked to that, the anti-coercion mechanism, that also fits in you can say almost in this concept of strategic autonomy, and the European Union that's flexing its muscles with increased autonomous trade tools to deal with unfair trade practices. And I'm sure that we will discuss the link between these two instruments as well. And on 9 September this year, the Commission launched a public consultation to collect feedback on a possible amendment of the blocking statute. The consultation runs until 4th of November. So you all still have 2-3-ish weeks to send in your comments. So obviously there's a lot to discuss on this very interesting topic, and we are very fortunate to have a stellar panel this morning with key experts and officials from the institutions, academics, and from the from the European Parliament. We have with us this morning Alina Nedea. She's from the European Commission, heads of the sanctions unit within DG FISMA, and it's her unit that is mainly responsible for the amendment of the blocking statute. We have Professor Tom Ruys, my colleague at Ghent University, a professor of international law, and one of the main experts in sanctions policy, and who has been following this very close by. And we have Marie-Pierre Vedren, member from the European Parliament, vice chair of the INTA committee. And Marie-Pierre is following this also, I think, from close by, mainly in her context as the rapporteur from the blocking statute, and also dealing with the anti-coercion mechanism. So the idea is that the speakers give a short introduction and a kind of an opening statement, and that we then have an interactive Q&A, because the idea of this webinar is also to collect your voice and your views on this issue, on the blocking statute, or on the possible amendment of the blocking statute. So I propose that we start with Alina to give a short introduction on what the Commission has in mind with regard to the blocking statute, and that we can then go to Tom and Marie-Pierre and then open the floor. So please, Alina, the floor is yours.
Many thanks, Guillaume. Thanks a lot also to the Egmont Institute, and very special thanks to the two co-panelists today, to Marie-Pierre and Tom. It's really a pleasure to be here and in such wonderful company. So what I thought I would do was to first of all tell you a little bit of why we are doing this. Why is the amendment to the blocking statute considered timely and necessary, and also appropriate in the current circumstances? And then very briefly what the main ideas are, knowing that at the present time, since we're still consulting the stakeholders on what could happen to the blocking statute, the number of concrete ideas that I can share is still very limited. The inception is still ongoing. So I think the real experience, you've mentioned that the blocking statute has been around since 1996, but to be fair, the only real experience we've had with it, with actually having to apply it, to put it in practice, to see what it does and what it does not do for European operators, started in 2018 when we somehow revived it following the US withdrawal from the JCPOA, the nuclear agreement with Iran. And we were pretty hopeful when we revived it that it would have the same knockout effect it had in 1996 when we put it in practice, that it would deter the US from applying those extraterritorial sanctions to our operators and perhaps to even withdraw them or waive them altogether as they did back in the 90s. Well, as we all know, that has not happened. So the blocking statute has had to deploy, if its political signaling did not work, it has had to deploy its legal effects, which were meant to be protective for EU operators. And what experience has shown in these 3 years of application is that it did not really deliver on its promises, and that many companies have been complaining that, in fact, some complaining that the blocking statute puts them between a rock and a hard place, and others complaining that, in fact, it's not protecting them enough from their peer business operators, which are damaging them as a consequence of extraterritorial sanctions. So the moment has come, we think, also because this commission defines itself as a geopolitical commission, to put right this situation. And there are, I think, 3 main reasons why we want to amend the blocking statute nowadays. One is political. And you have seen in the past months, and you have also mentioned the AntiCoercion instrument, that the EU as a whole is trying to take a much stronger stance in the world, is trying to reassert its role, and it's trying to reassert its autonomy and strategic sovereignty, if you want, on the international arena. And being able to withstand or to counter altogether extraterritorial sanctions imposition is part and parcel, and a very important one, I would say, of this world standing. The second reason is a matter of policy and of credibility. As I was mentioning, the blocking statute as it is has not fully delivered. I'm not saying it has been useless, it has not. It has delivered partly some results. It has been very effective, for instance, when it comes to sanctions concerning Cuba, but it has not delivered to its fullest extent. And we think that if we are to be credible in our policy, we need to have an instrument that actually works and that actually protects our economic operators from pressure by third countries. And the third reason is actually a reason of fairness, because so far, our conclusion is that so far it has been cost-free. It has simply come for free for third countries to impose pressure and extraterritorial sanctions on our operators. All the cost, the brunt of these extraterritorial sanctions has been borne by EU businesses. None of it has been borne by the imposing countries. They do not suffer from imposing extraterritorial sanctions. They do not feel the pain, hence they have zero interest, economic at least, to stop imposing those sanctions. They simply work for them and they work for free. So all these elements together have put us in the, have brought us to the decision that the time is now, and that we're going to amend the blocking statute. And the first moment where we announced this was precisely in a very symbolic communication we had in January this year about strengthening the openness and resilience of the EU financial sector. It's not just about the financial sector, but it is quite a lot about it. And that's where we announced the amendment. Now, what do we want to do in very broad terms with this amendment? 2 things. First of all, to streamline what's already there, because we think that the measures that are already in the blocking statute are not useless. They can work and they can protect to a certain extent economic operators from the consequences of extraterritorial sanctions if they are applied in a more streamlined manner, if they're clearer and easier to use. If you look, for instance, at the clawback clause in the blocking statute, it really makes you lose the will to live. It refers to the Brussels Convention, which was no longer in place by the time I finished high school. It's simply not usable. And on top, it's extremely difficult to use in 27 national jurisdictions. So this is just one example. So one thing we absolutely want to do is to streamline the procedures, to streamline the protective measures which are there. And then the other thing that we want to do, and where I would be extremely happy to get the views, of course, of my fellow panelists, and also of the public today, is the new volet that we would want to add to the blocking statute. And we announced that in the communication, which is the deterrent effect. We would want to add elements which tell the third countries which may want to impose extraterritorial sanctions. And this is not just about the US, it's also about other third countries which may be thinking about doing the same in the future. Don't do it. If you impose extraterritorial sanctions, this is what is going to happen. There will be a cost, there will be a reaction, it won't come cost-free. So hopefully with a set of reasonable and well-targeted measures that we could insert, that would somehow deter third countries from imposing extraterritorial sanctions in the first place. And if that doesn't happen, that would actually, those measures would be triggered, would be put in place, and would translate this cost onto the businesses of the third country in question, thus transferring the pain as a boomerang to them, and hopefully this way dissuading the third country from maintaining those measures. And all this would be overall much more protective of EU operators and much more credible instrument than what we have now. And I will leave it at that. I'm very, very happy to listen to my fellow panelists, and then of course to engage in questions and answers. Thank you.
Many thanks, Alina. We now have already a bit of a better idea on what you're cooking up, but I'm sure that there will be several questions and comments. But so I propose that we now go to Tom, maybe already for a kind of a first reaction, or in any case to hear his view on to what extent the blocking statute needs to be updated or not, what is going wrong, and how to improve it.
Well, thank you very much, Guillaume, and it's a pleasure to be here this morning. So congratulations on this event to you and your colleagues at the Egmont Institute. I noted in the announcement for the event that there's a statement that says that the blocking statute protects EU individuals and companies from extraterritorial sanctions. And I think I do not disagree that much with Ms. Alina Nedea when I say that that does not fully reflect reality, of course. If we look at the prohibition clause in the blocking statute, it's of course common sense to say that it has placed EU companies between a rock and a hard place, as we mentioned before. In addition, it's been mostly ineffective until now because the cost of not complying with the blocking statute is lesser than that of not complying with US sanctions. In addition to that, we know that national authorities within EU member states have little incentive to actually enforce compliance with that clause, with the provision in the blocking statute. And that there are issues concerning the burden of proof. So it's extremely difficult, of course, to prove that a company has given effect to secondary sanction, and that is accordingly in a breach of the blocking statutes. And so for those reasons, the prohibition clause has been mostly dead letter, save perhaps in the context of indirect enforcement proceedings. And so we've seen a number of proceedings where, for instance, Iranian companies, banks have sought to oblige European companies to re-establish commercial relationships, claiming a breach of the blocking statute. It's a bit uncertain for the time being whether or not these efforts are truly successful and credible. I think that will depend to a certain extent on the outcome of the Bank Melli proceedings, which are currently still pending. But overall, I would say that bottom line is that the prohibition clause is primarily unfair and also largely ineffective, and that increasing the penalties or the fines that would flow from non-compliance will not change that fundamentally. Does that mean that the prohibition ought to be thrown overboard? I would say no, not necessarily, because of course it still has an important symbolic role in terms of signaling the EU's condemnation of certain extraterritorial sanctions. What about the other clauses within the blocking statute, the clawback clause or the non-recognition? Well, I think that these can be useful instruments. They can be streamlined, as has been mentioned by Alina Nedea, but they are of course of a limited relevance only, and they do not of themselves create a strong deterrent impact for states that seek to impose secondary sanctions. In other words, merely tampering with the existing mechanisms within the blocking statute. And that is indeed what the 2021 Fostering Resilience communication mostly suggests, that will not fundamentally alter the current deficiencies of the blocking statute, raising the question what can be done to increase the deterrent impact. And so the question is, can we shift the cost? Can we shift the cost from EU companies? Hopefully not to EU taxpayers, because of course that will not bring us much further either, but rather to the countries that impose secondary sanctions on their economies. And I think that we can approach this from two perspectives. One question would be whether there is room for imposing targeted sanctions, for instance, on companies that benefit from secondary sanctions. I think there is a limited window, there is limited leeway for so doing. On the one hand, because oftentimes the companies of the country that imposes secondary sanctions, and we think primarily of US sanctions, they will also be subject to the same restrictions. Of course, they will be subject to the full force of US sanctions. So it's difficult to say that they indirectly benefit from the restrictions imposed on, let's say, EU companies. There are perhaps few exceptions where it would be possible to pinpoint companies that benefit or actually actively employ US secondary sanctions instruments. And one example that I would think of would relate to those companies that seek to make use of Title III of the Helms-Burton Act in order to bring proceedings against, among others, EU companies, right? So there, this might be a context where there might be, where one might consider targeted sanctions against such companies seeking to employ Title III of the Helms-Burton Act. Otherwise, the question is whether there is room for imposing sanctions of a more general nature, whether there's room for a more forceful response from the European Union. And of course, this is a discussion which is inevitably linked to that other instrument, which is currently under construction, and the anti-coercion instrument. The one thing that I would like to stress in this context, it may be a welcome development to indeed add to the toolbox of the European Union, for instance, to enable it to adopt access restrictions similar to those that the United States itself imposes. My main concern is that there is a need for much better, clearer legal articulation of where the European Union stands. And what I mean is that if you look at the blocking statute, it refers to unlawful extraterritorial sanctions, but it refrains from explaining what actually makes these sanctions unlawful. And in the margin, I note it always strikes me that the European Union itself says that it does not apply sanctions extraterritorially, which in itself is, of course, incorrect. It is inaccurate. The EU itself also imposes sanctions extraterritorially, but it tries to remain within the bounds of what the law of jurisdiction allows for. But this distinction is often missing in the discourse of the European Union, and I would think that it undermines its credibility. And this problem, in a way, this problem of credibility and legal articulation, I think threatens the effort to strengthen both the anti-blocking statute, but also the effort to come up with a credible anti-coercion instrument. And here we see a similar problem. Presumably the European Union wishes to act vis-a-vis coercive practices of other countries, such as not just the United States, but also Russia and China, which are presumably unlawful. But the reason why these practices would be unlawful and the threshold that would distinguish such practices from lawful practice is not made clear. Whereas it's probably not a secret when I say that the EU itself oftentimes engages in coercive practices of its own. In other words, to wrap up, I think that much more work needs to be done in order to explain where the EU stands in terms of both what it regards as an unlawful exercise of jurisdiction or an unlawful coercive practice. And that should be integrated in the exercise both of revamping the blocking statute, but also elaborating the anti-coercion instrument. The last point that I would like to flag is that I think in this context, it would be crucial for the EU to also join forces with other countries that are in a similar position, countries such as Canada and Japan and others, that could also be brought into the discussion to further develop where customary international law stands in this context. and to contribute to legitimizing certain extraterritorial practices. I'll leave it at that. Thank you.
Many thanks, Tom, for identifying already some elements of the blocking statute that can be improved, needs to be improved, to make some suggestions. You also mentioned this pending Bank Meli case, which is very interesting, and we had I could say, a remarkable opinion of the Advocate General already. So maybe we can pick that up later on, how and to what extent this could also maybe impact the Commission's proposal, and it remains to be seen when we will have actually the final outcome of the court. You called also for clear definitions at the end. And I think this specifically also relates to the anti-coercive mechanism, because in the end, I think this is one of the fundamental questions. What is the definition of a coercive policy of a third state? And I think this brings us with Marie-Pierre, who has been working in Parliament very actively on these issues. So Marie-Pierre, the floor is yours.
Thank you, Guillaume. And thank you first to Egmont Institute for organizing this event and for inviting me. And I'm delighted to be here and to have the opportunity to discuss on this very critical and crucial topic. First, I would like to draw a big picture of the current situation. And it's linked with Adina and Thomas already said. The fact is well known and clear. Without even mentioning the case of accidental American, the American sanctions on Iran or Cuba have illegitimate extraterritorial effect on our European company, which respect international law. And we should be saying everywhere that the European Union has the blocking statute and stakes mechanism to respond to such a situation. However, the reality is that they are completely ineffective in responding to real issues. And our company, for example, Airbus, Alstom, BNP Paribas, name few, but they are still facing unacceptable difficulties. And is it true that the new American administration represents an opportunity? And we must seize to put the subject back on the table, but let's not be naive, and the extraterritorial effect of US sanctions that back long before the Trump administration, and Joe Biden in the White House is unlikely to change anything. And I would like to make here a distinction that will be fundamental to better understand how I see the articulation between the blocking statute review and anti-coercion instruments. The United States takes advantage of its legislation to deviate it from its main goal and impose on everyone, European include, their goal. There is double objective: put pressure on companies to force them to leave a market, but also make public authorities such as the EU and member states to adopt similar sanctions. And there are two different levels of coercion and two different objectives. And in both cases, as European, we have currently no efficient means of action. And it's now time to move from suffering to acting. And it's a matter, like mentioned by Alina, of sovereignty and also about credibility for the European Union. And second, we need to reform the blocking statute to make it effective and efficient for our companies. I have to thank the Commission for having launched this public consultation. And to put on the work program 2022 this review. This is another proof that the European Commission has finally understood the need to strengthen our toolbox and to muscle our trade policy. And our main and only objective must be to make the EU blocking statute as a concrete and effective tool for the EU company compliant, and I insist on this aspect, compliant with international law to counteract the harmful extraterritorial application of sanctions. And I think that the first weakness of the current EU blocking statute is it's not enforcement. It was originally conceived as a political measure. And in 1996, it was intended to provide the US administration with a political justification for using waiver of extraterritorial sanctions towards Europe because of Cuba, Libya, and Iran. And the threat of application of the EU blocking statute was followed by a year of non-application. And it is since then perceived as a paper tiger, even by the EU companies. And this needs to be addressed and terminated. The second weakness of the current block limit impact of the blocking statute, legally speaking, the current regulation can only restrict the EU on economy. There is currently a lack of auxiliary and protective measure in the event that compliant with the blocking statute tiger, concrete foreign sanction against a complying EU company. And the upcoming concrete foreign review must address this issue and build retaliatory measures against non-EU company and institute acting coercive, and to create new protective and assisting measures in favor of the EU company if they are effectively attacked by foreign coercive action. A third weakness is the difficulty to the procedure, already mentioned also by Adina. There is a crucial need to ease all the procedure, to simplify the implementation of the measure, and to ensure the real access to market. And my third and last point, extraterritoriality is economic coercion, and not only for our companies. An EU blocking statute alone can only address parts of the overall problem. Indeed, when the US adopts sanctions against Iran with the well-known extraterritorial effect, the objective was also to push the EU to adopt similar sanctions. And this is clearly an inter-state dispute using economic coercion as a weapon. And in addition, other trading partners are following the same path in terms of unilateral action. A clearer example is China, which is also strengthening its trade policy by equipping itself with the necessary tool to take unilateral measures or even extraterritorial provision. And in the context of the COVID crisis, China did not hesitate, for example, to take illegal coercive measures against Australia, which denounced Chinese policy, and thus violating any rules of their bilateral trade agreement. And some boycott practice in China or in Turkey against European goods and services are also a reality. So in response to this situation and under the pressure of the European Parliament, in order to make sure that this instrument of European solidarity is acceptable and efficient to tackle economic coercion, we need to discuss the design of such an instrument, its scopes, in implication, and in functioning. And first, we need to work on the scope of the new instrument. It must be as broad as possible to include all different existing and future forms of coercion. And I would like to say that we should primarily be able to respond to manifest, unlawful, illegal, and unilateral measures, which fall out of the scope of World Trade Organization. We do not want to put the EU out of the multilateral order. We know all that the EU is at the forefront of defending multilateral system and World Trade Organization. However, the EU cannot be always the naive partner and not defending its interest. And as I said, extraterritorial effect of third country sanction is nothing but coercion for our European interest. And this is why the instrument must be a second level instrument after the blocking statute to deter and counter the third coercion country. And the blocking statute will help the company to counter the unlawful consequence of third country decision, and all the other part of anti-coercion instrument will be a supplementary threat to impose additional sanction in interstate dispute perspective. Second, we need to see what will the scope of the countermeasure. As I thought for enforcement regulation revision, we should be able to impose countermeasure in all the fields: goods, public procurement, services, and intellectual property rights, because services and IPR are growing part of our trade relation. And not being able to impose countermeasure in this field would weaken our credibility. And the EU cannot be limited in imposing countermeasures. We need to be really credible and efficient. And third, we have to evaluate how this instrument would work concretely, because many questions are raised in terms of proportionality of the measure, of consulting all the stakeholders, and in terms of also involving the parliament. And this instrument should be used in close cooperation with member states, stakeholders, but also with the parliament. And we all need to be involved in the process of determining the countermeasure, launching them, and monitoring their effect. It can be a commission-only prerogative. And this is the only way to overcome the decisions that could exist in the EU. We need to ensure that evolve through the process of defining such measure. And in order to be fully equipped to tackle extraterritoriality, the review of the EU Blocking Statute has to be complete by a strong anti-coercion instrument. This will bring additional leverage to fight against extraterritorial effect of third country. So to conclude, the white paper already mentioned by Alina and Tom in last January, the presentation in December of an anti-coercion instrument, the Commission work program for 2022 to review the EU Blocking Statute. The planet seems to be completely aligned. So the EU can be up that to current challenge and build our open strategic autonomy. So, and I think that it's important to say for all the member states, for all the stakeholders, and for our partner, that these instruments are not about protectionism. On the contrary, it's more about deterrence and fight back. However, it's time to make our partner understand that we are finally going to play on equal terms. Assertive, efficient, credible, it's our principle for European Union. Thank you.
Many thanks, Marie-Pierre. Actually, I think the points that you identified as the weaknesses in the blocking statute are quite similar to the ones actually identified both by Alina and Tom, so that's a good start. You called for quite strong deterrent measures in line, for example, with the ones now included in the enforcement regulation. But let me first actually invite all the participants to ask questions or come up with comments. I suggest that you use the chat box for this. Please briefly state your name and affiliation and keep your questions and especially comments as snappy as possible so that it allows me to see the wood for the trees. And also have to flag that unfortunately Marie-Pierre has to leave at 10:30, so please first focus on Marie-Pierre or get your questions and comments from Marie-Pierre out first. So while we are waiting for the first questions or comments, maybe let me already mention or ask a few issues. Maybe first of all, Marie-Pierre, you mentioned the Biden administration, and obviously this blocking statute is a sensitive issue in transatlantic relations. And I think you can also see this because only a couple of weeks ago, we had the first Trade and Technology Council meeting. And if you look at the joint statement, I think the blocking statute was not even mentioned. There is the description of the different working parties now that basically have to deal with basically everything, but not the most sensitive issues, including the blocking statute. So my question was if you or maybe Alina knows to what extent this is already discussed directly or indirectly with the US administration to test the water, or in any case to anticipate some reaction on that front. Now, maybe then a second question or comment for the speakers is something that Tom mentioned, which is, I think, quite important, relates to the burden of proof. And this also relates, I think, to the pending Bank Meli case before the Court of Justice. I don't want to go into the legal nitty-gritty of the case. But if you look at the opinion of the Advocate General, it is quite remarkable because basically the Advocate General argues that if a company, an EU operator, terminates business with a company in Iran, the burden of proof is with the EU company to show that it has terminated its business, not to actually be in line with the US sanctions, which is, I think, quite far-reaching. And we have to see to what extent that the court will follow this. But my question to Alina is, to what extent is this anticipated, or do you have specific ideas already at this point to deal with this burden of proof, which I think for the operators is a crucial issue. So maybe we can start with, I mean, these two comments or questions, and also take the opportunity to maybe already react to each other. Maybe I propose that we start in the same order. Alina, please go ahead. And in the meantime, I already collect some other questions or comments.
Many thanks, Guillaume. Let me first perhaps react to something that both Tom and Marie-Pierre have raised, which is the interlink between the blocking statute and the anti-coercion instrument. I think it's, I won't call it the elephant in the room because there's nothing to hide about it. It is what I can just say at this stage, because the proposal for the anti-coercion instrument is not yet there, and we are even further behind with the blocking statute, is that there is a very constructive and very thorough cooperation at the level of the Commission. As you know, there are two different directors general in charge of the proposals, but that doesn't mean that the Commission as a whole is not in charge of both. So we are really working as one, and there has been very close cooperation to make sure that one instrument does not preclude the other, and also that they make sense together, that when we have both proposals, they make sense and they make a credible whole, which is exactly what Marie-Pierre was saying, that we have to be credible and we have to give ourselves the instruments to react. On your question, maybe on the discussions with the Biden administration on the blocking statute, I mean, I would not know, for instance, the kind of concrete discussions that the delegations or the colleagues in the External Action Service are having at political level. And definitely Marie-Pierre will know more about the discussions that may be there with the US Congress. But I know that when it comes to working level discussions with the US administration, there is quite, we talk a lot about sanctions, and whenever we can, we bring in extraterritorial sanctions. And we have done so even, although it's hard to believe, during the Trump administration. So this is a recurring topic. For instance, we've not had an outreach event on the blocking statute with the US. We thought it's perhaps not the most a rich source of suggestions and ideas for the amendment, but we do discuss that. And then on the reversal of the burden of proof and the Advocate General conclusions in Bank Melli, I think that's a very good point, and I can already disclose that we are looking into. Well, first of all, there's an effect that we had not, I think, anticipated and that we see now in the Bank Melli case, which is that it ends up supporting third country companies against EU companies. And that's, I mean, I'm not saying it is wrong, because in the end, if an EU company breaks the law, it has to be liable towards anyone. That's just a general principle. But I don't think, my personal view is that this is not what the blocking statute was meant to do. It was meant to protect EU operators first and foremost. Now, after the conclusions of the Advocate General, we of course have to look into how the case law might evolve. And we did think whether the reversal of the burden of proof would not be a good way to strengthen the clawback clause when it comes, of course, to litigation between EU operators. So, for instance, one operator decides to apply extraterritorial sanctions, damages another EU operator. That second EU operator has, of course, the right to claw back, to claim back the damages. Would it be helpful, in order to support this claim, to reverse the burden of proof and to say to the first operator, which allegedly complied with extraterritorial sanctions, demonstrate why you did it? Because if you had a good reason to do it, you're probably likely to be able to demonstrate that as well. If it's a business decision, if you did not have the financing, if it's your business plan that was already drawn up a few years back. So this is something that we are considering, and I would be very happy to hear the views of participants today on this possibility. Thanks.
Okay. Marie-Pierre, you want to come in at this point? Please go ahead.
Just about the relation between US and the EU and the new administration. I think that we have a lot of issue with US, not only extraterritorial, but I think that it's important to say that on Boeing Airbus, we have already a provisional solution. On steel and aluminum, the EU push also for a solution. And because the EU is united and wants to show that the ES that we are in the conformity on international law, and we want to show that we are determined to defend our interests, we succeed with the Trump administration and also with Biden administration. So it's why I think that especially for extraterritorial sanction, we need to have the reform of blocking statute and also anti-coercion instrument to show that we have some instrument, dissuasive instrument. It's not about to use all the time our defend instrument, but it's a question of united of Europe and the question of credibility. So I think that to respond precisely, Guillaume, on your question, during the discussion in Pittsburgh, I think that extraterritorial aspect was not the subject, but all the discussion between the Commission, Member States, and US show that if the EU is strong, we have the ability to solve some issue. So it's why it's important to be completely aligned in the EU and to have all the instruments to defend our interests.
Many thanks, Marie-Pierre. Tom, do you already want to come in? Please.
Sure. Maybe a few points on the questions that you raised on the relationship with the Biden administration. I have little to add. I think that the sanctions policy is one of those few domains, perhaps within the United States, you have strong bipartisan support. So extraterritorial sanctions are unlikely to go away on short term. What we have seen with the Biden administration is, for instance, that they have in past months agreed to suspend the Nord Stream sanction at one point. That has nothing to do with the blocking statute, of course, because the Nord Stream 2 sanctions weren't included in the annex, so it's not a result of the impact whatsoever of the blocking statute. But I do not expect a fundamental change in US policy in that respect. On the burden of proof and the ongoing Bank Mali case, well, we still need to wait and see whether the court will follow the opinion of the Advocate General, of course. It's true that there is a partial reversal of the burden of proof in the opinion of the AG, in the sense that when one company provides indications that the termination of a commercial banking relationship is inspired by the impact of the secondary sanctions, that the company will have to demonstrate that there was another overriding reason. One flaw, though, in that opinion is that the Advocate General himself leaves leeway for the argument that the company is simply acting because it is for ethical or moral reasons, because it does not want to engage in relationships with a company that stems from a country that has a poor human rights record, or that engages in support for terrorist activities and what have you. So it does leave a lot of leeway, I think, still, in spite of this reversal of the burden of proof, for companies to come up with alternative justifications. But again, we'll need to wait and see what the court makes of this. On the link between the anti-coercion instrument and the blocking statute, I'm pleased to hear that the planets are aligned, but I'm still curious to see what actually the alignment will look like in the ultimate instruments. It's clear that if you look at the survey that was organized with respect to the anti-coercion instruments, the one form of coercion that is often put forth as a practice that ought to be covered by the new ACI is precisely the use of extraterritorial sanctions. I would add in as a footnote that one respondent in the survey actually also hinted that the Chinese blocking statute would be a form of coercion, which raises an interesting thoughts, however. So it remains to be seen to what extent extraterritorial sanctions will be included. Will they be included only in as much as they pose a threat to the EU's political and economic sovereignty, or also when they simply pose a threat to EU companies directly. I'm curious to see what the outcome will be. I do think that in as much as this is construed as a toolbox to engage in countermeasures, it should be framed in line with international law, and it should comply with the conditions that international law imposes on the recourse to countermeasures. And this is not just a question of proportionality, but it's also primarily, at least initially, a question of identifying what form of unlawful conduct you're responding to, what the illegality precisely consists of. And there, as I mentioned before, there's still a lot of work to be done in my view.
Many thanks, Tom. And I see we have several excellent questions, which actually follow up on a few issues already discussed. For example, Iana Dreyer from Borderlex asks, so we have already discussed the link between the new blocking statute and the anti-coercive mechanism. But in practical terms, Iana is basically asking how the Commission is thinking to merge or these processes. I think she really refers to the legislative process, because I assume that first we will have a Commission proposal on the anti-coercive mechanism. I assume that the blocking statute will come a bit later. So actually then the discussion on the anti-coercive mechanism will then already start also in Parliament. So then the question is how the debate on the blocking statute will follow this, or how, to what extent will it be complementary? I don't know if the Commission is, I don't know, for example, has the intention to streamline these processes or not, because obviously at a certain point, once you have a proposal, I mean, the dynamics already start by the legislators. So that's one question. And then I'm picking up only 2 or 3 questions, not to overburden you in this round. Coming back to the point that Tom mentioned on really on the legal basis, there is the basic simple question from Alexandre Roer from what will be the sources of international law the EU could use to define the unlawfulness of third country sanctions. Then we go, I think, a bit more into the legal discussion, but obviously very much needed and interesting. And then I will take one more question, if you allow me. There was the question from Fasson Justine. She's asking, the question that she asks relates to the enforcement of the blocking statute by member states. She basically argues or says that many member states do not have implemented the EU blocking statute into their domestic legislation, therefore not creating the necessary penalties for non-compliance. Is the European Commission planning to tackle this problem? So this really then relates to the role of the member states in the enforcement of this and how to improve this. And she basically asks, how can the Commission encourage member states to start enforcing and using the instrument? Justine Fasson from Sydney. So we have 3 questions. The last one on the role of the member states. The first one on the legislative, I mean, to what extent the proposals will go hand in hand. And the second question was, please remind me, was on the legal basis in international law. So considering time, I propose that Marie-Pierre, we can start with you, because we know that you have to go. So please go ahead to tackle these questions, or if you have other comments or questions, please go ahead.
Thank you, and sorry to have to leave, but I have 2 ministers today in Brittany, so it's quite difficult. A general message, because I have seen in the chat that the question about if escalation. I remember during the negotiation on enforcement, the argument to not enlarge the scope was always, be careful, we don't want escalation. Of course, we don't want escalation. We want free and fair trade. But we need, like we mentioned already, we need to be coherent, we need to be credible. So we need efficient instrument and proportional instrument. So it's why I think it's very important for the blocking statute reform and also for anti-coercion to be completely open during the proposal. Of course, after we have to discuss about legal aspect, we have to discuss about political consequences, but not to be at the beginning of the process or already closed about some proposal. And all the time, the EU sends a message in the EU and also with our third partner that we want to be compliant with World Trade Organization and international law. So I think that the EU has already demonstrated with all our toolbox that we don't want trade war. So it's important to keep in mind that the EU's interest is to defend fair and free trade, but it's also to be credible. So it's why blocking statute and also anti-coercion and also for the negotiation on foreign subsidy, etc., are very important. And of course, we have after legal discussion, because it's also really important that we keep our line. And we know, of course, that with US, we have also the challenge with China. And we already mentioned that China also take measure on extraterritorial effects. So it's very important, I think, that to be focused at this moment on a large instrument and a large reform, not to be closed on all the opportunity.
Many thanks, Marie-Pierre. I don't know if you have a couple of minutes to stay around or do you need to go?
Sorry, I have to go.
Okay.
And sorry for my voice. It's quite difficult today.
No, I mean, it was very clear and it's weekend, so please take them some time to rest. And many thanks for joining us. And yeah, I'm sure that we will follow up directly or indirectly these issues. So please go, and many thanks for having joined us.
Thank you. Thank you. See you.
Okay, Tom and Alina. So please stay because there are still a lot of questions. But yeah, I first give you the opportunity to react to the questions that I just asked. Tom, I don't know if you want to go first.
Sure, I was thinking ladies first, but I'm happy to.
Sorry, I now feel so impolite. Then Alina, please go ahead.
Are we not fighting for equality? Please, Tom, go ahead.
Apologies. Good. Okay, let me then turn to the question raised by Alexander Rohr on the sources of illegality. So how could you identify whether certain extraterritorial sanctions are unlawful, yes or no? Well, if you look at the enforcement regulation, it's clear that the basis of illegality is a violation of a trade agreement. And to some extent, extraterritorial sanctions can themselves entail a breach of trade agreements. And then it would be the easy case, let's say. It becomes much more difficult if the illegality that you invoke is one under general international law, where you argue that sanctions breach either the limits on the exercise of jurisdiction under customary international law, or when you claim a violation of the non-intervention principle, of which coercion is one of the two main elements. That's a bit, those norms are more indeterminate. There are a few clear examples where I think you can say that the limits on jurisdiction are overstepped. For instance, we know that the EU imposes sanctions also on that it applies its sanctions tools vis-a-vis EU companies abroad, meaning companies that are established under the law of one of the EU member states. Whereas if you look to the US sanctions, they will broaden the scope of application of their sanctions also to companies that are controlled in the form of for instance, shares that are controlled by companies established under US law. So they broaden the nationality nexus in a way that is in essence not permitted in the international law. So that would be one example of a breach. The most difficult prong is the coercion discussion. And as I mentioned before, that this raises the question, what amounts to a breach of the non-intervention principle? And traditionally, this was understood quite narrowly, and we see in the light of the process on the anti-coercion instrument that the EU itself seems to be adamant on broadening the scope of that non-intervention principle, but that may well create a boomerang effect in the sense that, of course, many sanctions adopted by the EU itself also entail an element of coercion, meaning that the EU will itself have to justify those sanctions as, for instance, countermeasures that respond to prior unlawful conduct, whether human rights violations or and the like. So it's not an easy discussion. The anti-coercion instrument could also be framed more broadly and not just limited to coercive practices. For instance, one might refer more broadly to breaches of general international law, so as to leave more leeway, but it's something that requires, I think, further thought.
Many thanks, Tom. Alina, please go ahead.
And I'm so happy that Tom replied first, because I was hoping he would take that one. Let me see the other questions that you raised. I won't go to the chat yet. So I let you, Guillaume, select the questions as they come in. The link in the legislative procedures. So how are we going to the Jana's question? How are we going to link the two? So obviously we're a few months behind the anti-coercion instrument, also because the work on the anti-coercion instrument started already last year, whereas the amendment to the blocking statute was only announced this year. So we are a bit décalé, but that is not necessarily a problem. So as I said, we are working very closely together already now on the drafting of the anti-coercion instrument. And our intention, which is something I didn't mention earlier, is to have the proposal for the blocking statute amendment adopted at some point in April next year. So that would mean that there's basically a 4 months gap between the two, which is not enormous if you think of the length of these procedures and the complexity. And most likely it will also be, but this is not yet entirely clear because it will of course depend on the legal basis. Most likely both the proposals will end up being discussed by the same bodies. So I think the same committee in the European Parliament and probably the same working parties in the Council. So that would mean that consistency will be ensured throughout of both, so that they just go together in parallel, but together in a consistent way. On the enforcement by member states, I mean, that is a very tricky one. Obviously, as Commission, we are monitoring the enforcement, and we do see that there are deficiencies. Now, we also see that member states are being put also between the same rock and hard place as the companies are being put. Because if you have two of your operators, one complying with extra-territorial sanction, the other is not complying, the other being hurt, but the first one either complies or is going to be put on the SDN list by the US and goes bankrupt, in the end, if you want to enforce, you're going to have to end up deciding who do you want to make it to get bankrupt. I'm slightly exaggerating, but it is extremely difficult for member states to take a position. So I'm not defending the non-enforcement, but I'm somehow understanding of the reasons that are behind. And the other element is that even in the situations where member states have acted, and I wouldn't say that there is so much demonstrated breach of the blocking statute, but in the cases where member states want to react, because of the nature of EU penalties, it is practically impossible in the current state of things that a penalty for the breach of the blocking statute will be as harsh as the consequences that would ensue for non-compliance with US sanctions. You don't comply with US sanctions and you get on the SDN list again, then that's it. There's no way out of there. There are some ways, but by the time you're out, you're bankrupt. So there needs to be an overhaul also of the national penalties for the breach of the blocking statute so that they somehow match or balance the risks of non-compliance with US law. So it's a very tricky one, and it's one that we're also looking into for the amendment. How do we go about it? Do we want to become harsher on enforcement, or do we want to find other ways to avoid this dilemma for national authorities and for companies, and to rather try to protect them differently?
Many thanks, Alina. There are several other questions which actually also relate a bit to the last point. For example, Steven Blokmans, director at SEPS, is asking what does streamlining more offensive tools means in concreto? Because indeed, if you read the documents that we have so far from the Commission, one of the key elements that you mentioned is indeed streamline the application of the blocking statute to reduce administrative burden. But could you maybe indeed specify a bit or give a few examples on what this actually would or could mean in practice? And then the second question, I do apologize, I just have to check here, from Daria Galperina, who is thanking us first for our presentation. And then She asks how the blocking statute could be strengthened to deal with over-compliance of certain companies with secondary sanctions. She mentions that often US companies would take a very cautious approach and would implement restrictions on business relations with EU companies, even if it isn't strictly required by secondary sanctions. I know Tom and Elina, if you have already comments or questions, and maybe let me throw in a third follow-up question on the discussion on legality. Again, Iana Dreyer from Borderlex asks specifically to the WTO dimension of both the blocking statute and the anti-coercive mechanism. I think obviously Alina will say it has to be, and it will be in line with WTO rules, but could you maybe then already specify a bit what the, without going too much in the legal nitty-gritty debate, what would be the key tricky elements from that perspective, from the WTO point of view? So we have the question on WTO, on the question from Daria Galperina, and the one on streamlining the procedure. I propose that this time then we start with Alina, and then we go to Tom.
Thanks a lot. Excellent questions. I have to say it's one of the liveliest outreach events we have done, and I'm very, very happy. And it's probably the merits of the co-panelists, because when I do it alone, I don't get all that many questions. So on streamlining the measures. So the idea to streamline refers to the existing measures. So the things that I was referring to, for instance, damages claims. Against whom exactly can you claim damages? We won't be able to list all the categories, and it will also depend in part on national law, but there are a few precisions that we can bring. So for instance, I wonder if it's something that we discussed at your event back in May. We were considering whether the damage clause, which currently says the article that damage claims can be brought against the person causing the damage or those acting in their representation or on their behalf, could one bring a damage claim against the lawyer of the person having caused the damage? Because there are hardly clear examples of someone acting in representation of someone else than a lawyer, particularly a lawyer who might be acting in representation of that person in actually causing the damage, for instance, by introducing a court case. So that is one of the things that we would want to clarify, but of course a little bit more research is necessary. Then we thought whether it would be helpful, of course, to clarify the jurisdictional rules as well, because it's extremely difficult and it does require either a good compliance department or quite a lot of money to spend on lawyers, and nothing against lawyers, I am one myself, to figure out where exactly you can bring that damages claim. Then the other element and still on the damages claim, it says that the action can be brought in the member state where the defendant has assets. How do you find out where the defendant has assets? It's not an easy task. Some things are clear, but others are not. And many of the companies we have spoken to tell us we would be willing to bring damages claim, but we just don't know where this guy has assets. Tell us. So this kind of things are fall under the category that we have called streamlining. The authorization procedure. So you know that in the blocking statute, there's this prohibition to comply with extra-territorial sanctions and the possibility to exceptionally be authorized to do so. And there is a misconception, I think it's almost a myth by now, that the authorization procedure is extremely cumbersome, takes very, very long, and nobody really knows what to expect. Now, we've never received this kind of complaint for someone who actually applied for an authorization.
Could I maybe just step in, and I have a specific question on to what extent is this actually being used? If you could also mention this, for example, with regard to recently with vis-a-vis Iran.
It is being used, and it has been used, and unfortunately I don't have the latest numbers, but it has been used, definitely. It has been used both with regard to Iran and both with regard to Cuba, and there have been authorizations and there have been denials. So it is a procedure that works, but by its own nature, it's extremely confidential. We don't want to tweet about company X having asked for an authorization. So this is why I think that there's a lot of misconceptions around it, a lot of mistrust, and companies who say we just don't come because we don't know what to expect. Well, you never know exactly what to expect when you leave the house either in the morning. So this is something that we also want to try to clarify as much as we can. And then other elements as well. So this is the streamlining part. Now on the countering part, on the really defensive and deterring side, there are things. If you look at the public consultation, which is still ongoing until the 4th of November, you will see that there are already hints of things that we might want to introduce in the blocking statute to deter third countries from imposing sanctions in the first place. One of them is, for instance, fiddling with the visa restrictions for business trips for CEOs and important executives of foreign country companies. The other would be to blacklist directly. I mean, blacklist sounds very, very harsh. We will need to figure out what that can mean in practice and what kind of steps will be needed. Blacklist companies which either benefit from the extraterritorial sanctions or have some other sort of link with those sanctions, excluding them from certain markets, excluding them from the possibility of receiving EU financing, from the possibility of applying for EU tenders, and so on and so forth. So this is the new volet that we would want to add to the blocking statute to give it teeth, not only to allow you to claim damages when the damage is done, but to try to avoid the damage in the first place, and also to try to shift the cost I was mentioning at the very beginning to the operators of the imposing country. Now, very quickly on Daria's excellent question, I think I would very gladly, maybe not necessarily now because I would be calling on him, I would very gladly pick Tom's brains on this one. Can we also, if we say that what we want to counter is extraterritorial sanctions, can we also catch over-compliance with sanctions which are not necessarily extraterritorial in themselves, but just companies of the third country make them extraterritorial by being extremely cautious? So Daria, this is definitely something we're thinking into, and if anybody has good ideas on that one, please don't hesitate to reach out. And on WTO, because I see time is running out and I've spoken way too much, and Tom will definitely have more interesting things to say. As you well anticipated, Guillaume, yes, everything is going to be fully compliant with WTO. Nobody ever expected me to say something different. Thank you.
Okay, Tom, I think just because I think it's important, nevertheless, although obviously we could discuss this for still for a very long time, but we need to end at a certain point. That maybe before I give the last word then to Tom, Alina, I don't know if you have final comments or questions, or maybe I will give you maybe one final opportunity to maybe direct to what Tom will say now. So let me first then give the word to Tom, and then Alina, I give you the final word if you have urgent issues that you still want to get out there. So Tom, please go ahead.
Thank you, Guillaume, and many thanks to Alina for the useful insights as always. A few points, I'll try to be relatively brief. To come back to the point on the enforcement at the national level of the blocking statute, it's been pointed out before that, well, some countries have dragged their feet in terms of implementing the blocking statute. There's also, of course, a discrepancy in terms of the fines that might follow, whether administrative or criminal penalties. One suggestion that I've come across relatively recently was the idea to provide for infringement proceedings against states that fail to implement the blocking statute, which in my view would be a bit of an absurd idea, incredibly difficult to actually implement, but also again, perhaps a form of shooting yourself in the foot at the EU level. So that does not certainly seem a helpful recommendation in my view. Secondly, on the authorization procedure, this is of course in a way a double-edged sword, in the sense that if the authorization would be quasi-automatic, you lose the deterrent impact, whereas if there is no guarantee for companies that their requests will be met, there will be a certain reluctance on the part of companies to seek one, because they might fear that they will put themselves on the radar, and that they might be caught in the net of the blocking statute and subject to fines later on. So I assume that they can be accommodated to a certain extent by allowing companies to contact the Commission on a no-name basis. Third point, on overcompliance. Well, we certainly see that overcompliance is still increasing. I think that these days it's become actually difficult to, for instance, send something by express delivery, a parcel to companies that are on the US sectoral sanctions list, but not on any EU sanctions list. I've recently discovered that some companies will simply refuse such deliveries, whereas a company such as DHL will require you to guarantee, as the sender of such a parcel, to guarantee to ensure that the package is in compliance not just with EU sanctions law, but also with US sanctions law. It's quite telling, and I'm not sure that whether that would be fully in line with the blocking statute, of course. So over compliance is still increasing. It's a problem, but one that, in my view, cannot be caught by the blocking statute. In essence, the blocking statute only covers actual compliance with the US secondary sanctions instruments. If a company would voluntarily go beyond that, legally speaking, it's not properly a breach of the blocking statute to begin with. For that same reason, whether over-compliance can be tackled through certain countermeasures seems unlawful, because of course that conduct in itself on the part of companies is in a way, it's an indirect consequence, but not a direct result of a third state's legislation. So it does not stem from an unlawful conduct, strictly speaking, of a country imposing extraterritorial measures. So it's a difficult one, but perhaps I'll need to think on it a bit more in light of Alina's question. Lastly, on the role of the WTO and the link with the WTO dispute settlement mechanism, I think when you look at the enforcement regulation, which seeks to respond to breaches of trade agreements, there is an interesting question whether the imposition of measures responding to a breach of the WTO agreements, whether it is fully in line with the lex specialis, the special legal framework created by the WTO, because of course ordinarily one would have to await the outcome of the WTO dispute settlement proceedings, which, as we know, are of course in a way handicapped with the current deadlock at the level of the WTO appellate body. I think the situation is somewhat different if the unlawful act that you seek to respond to is not a breach of a trade agreement, but something else, a breach under general international law, such as a unlawful exercise of jurisdiction or a breach of the non-intervention principle. I think in such a case, you're removed from that lex specialis, the special legal framework of the WTO law, and you should not encumber with seeking to comply with its internal dispute settlement mechanism. So there I actually see less of a problem under WTO law than perhaps with the enforcement regulation itself. But it's a very interesting point.
Many thanks, Tom. And with regard to thinking about the issue of overcompliance, you have until the 4th of November to make a submission to the public consultation. Many thanks for all your views. I mean, going a bit more in the legal nitty-gritty of the things, but also zooming out. But sorry, Alina, I give you the floor for if you have a few final comments or if you want to reply to a few issues that Tom mentioned, please go ahead. And then I think we have reached the time to close the show.
Thanks a lot. I think all I could add at this stage is once again and quite predictably my huge thanks to Tom and to Marie-Pierre, who's no longer here, and of course to you, Guillaume, for organizing this, for being here, for facilitating the dialogue. Deadline indeed is on the 4th of November at 23:59. I sound like a broken record. I always say the same thing. If you don't make it by the deadline, please don't hesitate to also share with us your thoughts afterwards. But it is a little bit more complicated for us afterwards to rely on them formally in our proposal, because there needs to be a bit of transparency and everybody needs to know who has contributed and so on and so forth. But if you submit your replies by the deadline and then you realize you've forgotten something extremely important, don't hesitate to send it the day after or the week after. And also, if you want to discuss with us, if you still have questions about the questionnaire that's out there, about what we're looking for, don't hesitate to reach out to us and informally, and we'll try to clarify that as much as possible. And so, yeah, thanks a lot.
Okay, many thanks. And first of all, I want to thank both you, Alina and Tom, and also Marie-Pierre for your insights and your views. I think things are a bit clearer for us with regard to what you're picking up and on what is actually, I mean, what the tricky parts will be and what the challenges are. Also want to thank the participants for their questions and comments. I do apologize. I think we collected most questions and comments, but if not, I will definitely send, for example, I see here some comments from Erika Moret from the Graduate Institute. I will definitely collect her comments and questions and send these to the speakers. But at this point, I think I can only say thank you and have a nice day. Many thanks. And I'm sure that we will follow up on all these issues later on. Bye. Have a nice day and thanks.